The previous video walked the matrix as if the decision were open. For a lot of coaches watching this, it isn't open. The practice is already running. Stripe is depositing payments. Clients are signing engagement letters. Revenue is real. If no entity has been filed, the matrix already chose for you. You are a sole proprietor. This video names what that actually means in operating terms so you can decide whether to keep it or move. Started coaching, never filed anything? The default isn't a neutral resting state. Sole proprietor is a specific legal status with specific consequences attached. The IRS treats you as a sole prop the moment you accept paying clients without an entity. No filing required, no paperwork, no fee. The status arrives automatically. Most coaches sitting in it didn't choose it. They just didn't choose anything else. This video walks the practical consequences so the choice stops being automatic and starts being deliberate. Sole prop status carries 5 operational realities that show up the day a client dispute does. Personal liability is unlimited. Your checking account, your vehicle, your home equity all sit in scope if a contract goes sideways. There is no corporate veil to maintain because nothing exists to pierce. Your social security number is doing double duty as your EIN on every W-9 and every contract, a privacy posture you probably didn't choose intentionally. Schedule C is the federal tax treatment, identical to a single-member LLC by default. And the day you formalize, a chain of follow-on work begins. Bank account, EIN, contracts, naming. Forming the LLC doesn't change one thing some coaches expect it to change. Tax treatment on day one is identical. A default single-member LLC files Schedule C, exactly like the sole prop did. The IRS treats it as a disregarded entity for federal income tax purposes. The entity exists for liability, not for tax differentiation, until you make a separate election. The dimension that does change the moment the formation confirmation hits your inbox is your exposure. That's the lever the filing pulls. That's the protection you're buying with the $150 state fee. Revenue is the wrong trigger for formalization, and I want to be direct about why. A lot of coaches set themselves a mental threshold. Once I cross $50,000 in revenue, I'll form. The reasoning is that there isn't enough at stake below that number to bother. The reasoning falls apart on a single fact. A lawsuit at $5,000 of revenue reaches the same personal assets as a lawsuit at $150,000 of revenue. The right trigger isn't a number. The trigger is the moment you start taking clients or accepting money. From that moment, exposure exists, and the layer either exists or it doesn't. Here's how that plays out in a scenario I've seen variations of more than once. 6 months into practice. Stripe is depositing payouts into personal checking. Convenient, never got around to opening a business account. A client in a group program is unhappy with the value, files a chargeback, then threatens small claims court for the rest. With an LLC formed, the small claims filing names the LLC. The personal savings account is out of scope unless the plaintiff can pierce the veil, which is hard. Without the LLC, the filing names the coach personally, and the personal checking account is fair game for collection if a judgment lands. Read this whole video as a description of trade-offs, and you'd miss the actual lesson. Forming the LLC isn't what makes the practice legitimate. Plenty of coaches build real, ethical, productive practices as sole props. The IRS recognizes them. Clients sign engagements with them. Insurance carriers underwrite them. What the LLC actually provides is a liability layer between the practice's disputes and your personal financial life. The earlier the layer exists, the more exposure you avoid in the window before it does. Past disputes don't get covered retroactively by a future formation. Formation date is the line. 2 quick self-checks before you move on. First, are you currently taking clients or accepting coaching payments without an entity formed? If the answer is yes, you are a sole prop today, and Module 4 is the work in front of you. Don't read past this and treat formation as a someday item. Second, if you already have an entity, log into your state Secretary of State portal and confirm it is in good standing. Lapsed entities lose their liability protection. I've seen coaches with LLCs they formed in 2021 that the state administratively dissolved in 2023 for missed annual reports. They didn't know. Check the portal, confirm, then continue.